My video was off. Okay, thank you, Supriya madam, for helping me
Welcome,
in this
Sarguja. So you can start now.
instruction session
Just a second. I welcome you all
by
to this alumni
sharing my
lecture series,
PPT on the
which
topic.
is going to be sixth in number, which is to be delivered by Saman Narayan Upadhyay, who is assistant professor and head of the department law in Sarguja University, Chhattisgarh. And before he starts his formal lecture, I would like to request Jitin Kumar, our research scholar, to introduce today's speaker. Jitin, please.
थैंक यू मैम। सर्वप्रथम कार्यक्रम की प्रणेता डिपार्टमेंट ऑफ ह्यूमन राइट के हेड प्रोफेसर प्रीति मिश्रा मैम, प्रोफेसर सक्सेना मैम, शशि कुमार सर एवं डिपार्टमेंट ऑफ ह्यूमन राइट के समस्त फैकल्टी मेंबर को प्रणाम करते हुए मैं जितेंद्र कुमार सरोज इस ऑनलाइन माध्यम से जुड़े समस्त वरिष्ठ एवं कनिष्ठ साथियों का हार्दिक स्वागत एवं अभिनंदन करता हूं। जैसा कि आप सभी को विदित है कि विगत कई सप्ताह से बाबा साहब भीमराव अम्बेडकर विश्वविद्यालय के मानवाधिकार विभाग द्वारा व्याख्यान श्रृंखला का आयोजन विद्वत जनों द्वारा, विद्वत शिक्षकों द्वारा किया जा रहा है। इस व्याख्यान श्रृंखला का छठा व्याख्यान आज प्रस्तुत होना है। इस व्याख्यान श्रृंखला में आज संत गाहिरा गुरु विश्वविद्यालय सरगुजा अंबिकापुर छत्तीसगढ़ के डिपार्टमेंट ऑफ लीगल स्टडीज के हेड असिस्टेंट प्रोफेसर समन नारायण उपाध्याय सर द्वारा फिलॉसफिकल फाउंडेशन ऑफ ह्यूमन राइट्स विषय पर अपना व्याख्यान प्रस्तुत किया जाएगा। निश्चित तौर पर सर के व्याख्यान से हम सभी लाभान्वित होंगे। सर, इसके पहले कि सर अपना व्याख्यान प्रस्तुत करें, मैं सर के शैक्षिक एवं विभिन्न प्रकार के प्रशासनिक पदों के दौरान उनके शैक्षिक अनुभव आप सभी के सम्मुख साझा करूंगा। सर को लगभग 9 वर्षों का शिक्षा के क्षेत्र में अध्ययन और अध्यापन का विशेष अनुभव रहा है। सर जूरिस्प्रूडेंस एंड लीगल थ्योरी, कॉन्स्टिट्यूशन लॉ ऑफ इंडिया, क्रिमिनल लॉ, बिजनेस लॉ, टॉर्ट लॉ, इंटरनेशनल लॉ, ह्यूमन राइट्स इत्यादि विषयों पर विशेष योग्यता रखते हैं। सर इलाहाबाद हाई कोर्ट बार एसोसिएशन में सर का 7 वर्ष का बार अनुभव रहा है। सर ने एमएससी, एलएलएम, यूजीसी नेट क्वालिफाई किए हैं। सर 3 पुस्तकों के लेखन कार्य से भी जुड़े रहे हैं। साथ ही सर 10 से अधिक राष्ट्रीय एवं अंतर्राष्ट्रीय जर्नल में सर का आर्टिकल पब्लिश हो चुका है। विभिन्न प्रकार के न्यूज़पेपरों ने सर को स्थान दिया है, सर के लेखों को स्थान दिया है। सर 2012 से 18 तक विभिन्न सेमिनारों का सर ने आयोजन किया और उस आयोजन में सर की विशेष भूमिका रही है। सर गेस्ट लेक्चरर के तौर पर विभिन्न विद्यालयों में सर ने अपना व्याख्यान प्रस्तुत किया है। इसके साथ ही सर लगभग 30 से अधिक राष्ट्रीय एवं अंतर्राष्ट्रीय स्तर के सेमिनारों में अपना पेपर प्रस्तुत करने के साथ साथ सर उसमें प्रतिभाग लिए हैं। सेवा के दौरान सर कई बार पुरस्कृत किए जा चुके हैं। विभिन्न एकेडमिक कमेटियों में सर सदस्य रहे हैं, प्रशासनिक कमेटियों में भी सर सदस्य रहे हैं। विभिन्न प्रकार के जर्नलशिप में सर को मेंबरशिप प्राप्त रही है। कई संगठनों के भी सर सदस्य रहे हैं। इस प्रकार अपार अनुभव की कोई कमी नहीं है सर में। निश्चित तौर पर इस अनुभव का आज हम सभी अनुभव का लाभ उठाएंगे और ऐसी हमारी शुभेच्छा है कि सर इस कार्यक्रम के उद्देश्यों को फलीभूत करते हुए हमें कृतार्थ करें। समन नारायण सर।
Thank you, Jitin sir, for inviting me with a very vast introduction, which actually I do not possess. I possess only one introduction of myself, that I am a student of Professor Priti Saxena Madam, Professor S.K. Bhatnagar Sir, Professor Priti Misra Madam, Professor Sasi Kumar Sir, and Professor Rasida Atahar Madam. This is my introduction which I use to carry everywhere, wherever I go. Nevertheless, thank you very much for introducing me, putting a positive gloss over the things. Today, I got this opportunity to interact in my alma mater department, in fact, with passed out students. I hope that current students might be there. And right now, I have seen that perhaps Professor Priti Saxena ma'am has joined. तो मैडम को मैं सादर प्रणाम करता हूँ मैम को जी, आपके चरणों में अपना सिर झुकाता हूँ मैम। जो कुछ भी सीखा मैम, आप लोगों से सीखा है, और आज आपके सामने ठीक मैं अपने LLM के क्लास का किसी टॉपिक पर प्रेजेंटेशन देने के लिए आपके सामने खड़ा हूँ। मैम आज लाइट हमारे यहाँ नहीं है, तो थोड़ा सा यहाँ मैम, really I am fortunate to be people of yours, and again I am here with a very small topic for discussion, in fact. So before I begin with the topic which I have chosen for the discussion of the day, I would like to put I would like to make some cases before this academic gathering. Supriya madam, please come to the next slide. No, you have turned to yes, next slide only. So I'm making few cases before you, before I start with my discussion on the philosophical foundations of human rights. First case, Lawrence versus Texas, well-known case, wherein LGBT has got in US some in their private affairs, and one of the very so-called Texas sodomy law was struck down on the ground being voice of 14th Constitutional Amendment Act of the US Constitution. And in fact, in this case, US Supreme Court has overturned the Bowers versus Hardwick case, which held in the past, that is in 1996, that Texas sodomy law was constitutional. And turning towards the Indian judiciary, if we look towards the Delhi High Court, this High Court had opportunity to discuss on the same issue in the Naz Foundation case, Naz Foundation versus Government of NCT of Delhi in 2009. The Chief Justice of Delhi High Court, A.P. Shah, and Justice S. Muralidhar, they were asked, in fact, to look into the right to privacy, right to life, right to personal liberty of the LGBT. LGBT term is well known to everybody, so I'm not going to explain what does it mean by what LGBT term is standing. So in their private affairs, Naz Foundation case, in fact, the Supreme Court, the Delhi High Court was very much admiring to the Lawrence decision of the US court, and has decriminalizes section 377 of the Indian Penal Code, that was criminalizing the unnatural offenses. And in this case, at a great length, number of the commissions on the moral values, law and morality were inquired, and ultimately the Delhi High Court has come to the point, come to the conclusion, in fact, that the section 377 of Indian Penal Code is vice of Article 14, Article 21 of the Indian Constitution, which is stipulating the fundamental rights of every human being. So thereafter, what has happened in the Indian judicial arena? In Suresh Kaushal versus Naz Foundation, the Delhi High Court's verdict in 2009 was challenged, and in fact, the division bench presided over by Justice G.S. Singhvi, Justice S.J. Mukhopadhyay, they in fact overturned in totality the verdict of the Naz Foundation, and they upheld that Section 377 is not unconstitutional. It does not have any kind of bias with Article 14 or Article 21 of the Indian Constitution. And the Section 377 is constitutional. However, the Supreme Court left the room open for the legislature to look into the matter, and if legislature wants to repeal the, then there would not be any kind of legal constraints in terms of the decision passed by the Supreme Court in Suresh Kausal case. But later on in Lokesh Tarna versus Union of India in 2018, again the 5-judge constitutional bench was called upon to discuss on the issue in hand. And again, the same Section 377 of Indian Penal Code was called in, was again challenged. In this case, the Supreme Court of India, through its constitutional bench, unanimously does not overturn in totality the Suresh Kumar Kausal's verdict, which was passed by this court only in 2014. Rather, partially the effect of Suresh Kumar Kausal was overturned in Navtesh Singh Johar, and Section 377 was held unconstitutional only to the extent where it was directing to impair the rights of the LGBT or the persons belonging to the same sex if they are consenting and they are doing some unnatural things at private place. Then it Section 377 would not have any operation upon their work. In fact, in this case, Supreme Court made one observation that I have written over here. Et domus sua quid est tutusium refusium. Meaning of this term is, this is the Latin term, meaning of this term is, a man's house is his own castle, and in the house of any man, he cannot be demanded to act in a particular manner. And if a man is doing something in his own house, then any attempt from the judiciary or any attempt from the legislature to regulate their personal affairs would not serve the purposes, any purposes belonging to the social order, public policy, morality, or decency. So this is the case which I wanted to make to you in first slide. Supriya madam, please come to the next slide. Yes, in this case, National Legal Services Authority versus Union of India in 2014. Here, the 5-judge bench, the division bench of the Supreme Court, in fact, given 7 directions to the central as well as the state governments regarding right to self-determination of the Hizraj, Inanj, and the Supreme Court directed to the central government and the state government to treat them as in the category of the third gender and to grant legal recognition of their gender identity, to take steps to treat them as socially and educationally backward classes. Most important thing is this: the Hizras, the Indians, third gender persons, are the transgenders as well. They were directed by the Supreme Court to be treated by the central government and state governments as the socially and educationally backward classes. For what purpose? For the purpose of extension of the reservations in the case of admissions in the educational institutions, as well as for the appointments in the public offices. And here, the Supreme Court perused Article 6 of the UDHR, Article 16, 17 of the ICCPR, whereunder the right to life, personal liberty, right to self-determination of the persons have been declared as the human rights of every human being. Please come to the next slide. This is my last case which I want to make over here to begin with my philosophical foundations of the human rights. Recently in 2019, in Joseph Sain versus Union of India, the 5-judge constitutional bench of the Supreme Court has decriminalized Section 497 of the Indian Penal Code, ruling that this Section 497 is in fact standing in the voice of the Article 14. In this Section 497 of the Indian Penal Code, the adulterer was to be prosecuted not by the adulteress or not by the wife of the adulterer, but only by the husband or any nearby relative. So here the Supreme Court has made one observation that the victim is the husband or the family members of the adulteress. Then how the wife of adulterer could not be victim of this adultery? So here this section has been decriminalized on one ground that it is making distinction or discrimination between two women. First is the adulteress, second is the wife of the adulterer. On the other hand, this section of the Indian Penal Code is making adulteress a commodity of her own husband, of her own family members. So we cannot allow subjection of any human being to any other human being. If it is allowed, if it is kept on going, then Section 497 would definitely stand in the violation of right to equality guaranteed under Article 14. So, my dear friends, in this 5 judges bench, that is a constitutional bench, as I have been taught by my most reverend professors and teachers, one of the judge was Rohinton Fali Nariman. He is one of the very renowned judges of the Supreme Court of India. In fact, the person who was introducing him had opportunity to speak about Fali Nariman, that if he had not been a judge, he would have been a religious preacher, some guide, some priest. So, as per his own wisdom or his inclination towards the religion, Justice R.F. Nariman has inquired number of religious documents. There he found that in the case of adultery, both the adulterer and the adulteress were sentenced to the death by drowning. And in the Roman Lex Lulia Adulteris Corsendis of 17th BC, Emperor Augustus' daughter Julia was punished for adultery with banishment. She was sent to the other country. In 7th commandment of the Judaism, death penalty for the adulterer as well as the adulteress is prescribed for any kind of offense of the adultery. Please go on the next slide. Observation of Justice Nariman is still continued. Again, he turned his wisdom towards the Christianity. In Christianity, for the offense of the adultery, the punishment was the stoning to the death. Fali Nariman himself wrote in his judgment that Jesus uttered in Bible that let him who has not sinned cast the first stone to execute death by stoning to a woman for the adultery. Let us turn towards the Indian mythology, Hinduism, and Islam also. Gautam Dharma Sutra, if a man commits adultery, he should observe a life of chastity for 2 years, and if he does so with the wife of a Vedic scholar, for 3 years chastity he has to observe. So, in comparison to other, forgive me if I am offending to anybody, but in comparison to other religious injunctions, what has happened in the Hinduism, there is nothing about such severe punishment except to observe life of chastity. In Islam, in its chapter 24, that is known as An-Nur, the Quran, the verse number 2 says that the adulteress and the adulterer flog each of them 100 strips. Both persons have to be executed such kind of the punishment. Flog each of them 100 strips, and let not pity for them detain you from obedience to Allah if you believe in Allah and the last day, and let the party of believers witness their chastisement. So, my dear friends, my most reverend teachers, with these basic cases, just I'm turning towards my topic. In fact, if we look into these things, what we are finding that the concept of human rights, which right nowadays we are having, were not present in the past. Many things have been done, and many things are being done till date too, and many things are yet to be done in future. So let us begin with our discussion, and again we will take up some examples from my previous slides. Please turn to the next slide. Supriya madam. In fact,
Sir,
I
have
am
done.
going here to discuss about the theological foundations of human rights. Yes, Supriya madam. कोई दिक्कत है क्या?
नहीं सर, मैंने कर दिया था, मुझे लग रहा है कनेक्शन
अरे
प्रॉब्लम
दिखा
हो रहा है।
दीजिए जी। 2-3 दिन बड़ा सोच के बनाए मैडम। मैं जानता था मेरे टीचर्स वहाँ रहेंगे तो कुछ पीपीटी ठीक से दिखा, नहीं तो
हाँ जी सर,
डांट
मैंने
देंगे
कर
तो
दिया
ठीक नहीं लगेगा ना।
Because of the connectivity, some problems happen.
अगर न चल पा रहा हो तो मैं ऐसे ही बोल दूं। पीपीटी न चल पा रही है तो
मैम
दिख नहीं रहा है क्या? मेरे को तो शो कर रहा है।
No, is it visible to me? It is visible.
Yes ma'am.
नहीं, next PPT isn't come. No problem. So just I'm continuing with my discussion.
Okay, sir, you tell me to check.
Here, yeah, I think there is some internet glitches from my side. Am I audible to everybody properly?
Yes, sir, you are audible.
Yes, sir. Yes, sir.
Yeah, thank you. So, Jitin sir, this is my first slide of the topic which I had taken up for my discussion. That is the theological foundation of human rights. If we look into the मैम, दिक्कत मेरी तरफ से थी लग रहा है, कुछ नेटवर्क का इश्यू मेरे यहाँ ही है. So in any of the religious scripture we cannot find the term like human rights. Nevertheless, if we turn the pages of the religious text, we will find many bases which are supporting to the conceptions of human rights, which are giving some values, which are giving some ethics to go ahead to serve the humanity. And the theology, in fact, it is not only presenting the basis to the human rights theory, but that these rights which are to be held by the human being is supreme, because these rights are stemming from the supreme being. Let me tell you, in Hinduism, in Christianity, in Islam, everywhere you will find that the human is the creation of the God. Religion can say that human is not creation of God. Every religious text are teaching to us, that we have been created from the God. हाँ, दिख रहा है सीपिया मैडम. So what is happening, in fact, in Christianity, what has been said that Adam has been created by the God in his own image. In Hinduism, it is said that God is everywhere, and science has proved it too. Discovering the God particle, कण कण में ईश्वर है. God is everywhere. So we are in fact created by the God with a divine stamp. We are stamped by the God, and this divine stamping is telling to us what? That we are having a high value of worth. We are not like coin or the currency which has been made by man with the same dimension, same metrics, same values. Rather, we have been stamped, we have been created by the God with a divine stamp, having our distinct and separate worth and values. In Talmud, there is a proverb that every person can claim that he is a creation of God, and God has created everything, so he is entitled for everything whatever is here in this universe. And these values of worth, what we are having, being created by the God, is inviolative. It is above all the mortal authorities. No one can take either of these rights from us. This is what the theology speaks to us about the foundations of the human rights. Next, please. Next slide. Yes. If we have been created by the God, of course, God is our common father, and we are the common child of the God, and we are the child of the God. Then, of course, we have common brotherhood. And this concept of fatherhood of God and brotherhood of man, I have written over here, gives number of rights gives rise to the number of rights which are equally available to every human being without any kind of discrimination. In some religious texts, we can find that a common humanity, and from this flows a universality of certain rights. For example, limitations on slavery, justice to the poor, fair treatment of strangers, racial equality, protection of labor, right to hold property, right to life. These things are stemming from this theological foundation of human rights, wherein we are finding the fatherhood of God, that is the common father principle, and brotherhood of men, common children principle. Nothing more than this, we can speak about the human rights which we can gather from the religious text, that is the theology. If we go in more detail, we will find some discrepancies, some discriminatory provisions where women were, in this theological text too, women were subordinated to the men, some racial, some caste inequalities are in existence in this text. But we are not concerned about all those things. We are concerned only to that part of the theology which are giving some sound basis to the development, or to the development of this human rights concept. Yes, come to the next slide, please. Now I will discuss the natural law theory that has given autonomy to the individual. शिवप्रिया मैडम, नेक्स्ट स्लाइड। थोड़ा जल्दी जल्दी करें, ज्यादा जो है फिर चला जाए।
अरे शिवप्रिया, बीच में कहाँ चले जाते हो?
मैम मैंने कर दिया है।
जी मैम, यस मैम, यस। ये तो मैं चाह रहा था कि जिसको बनाया था मैम ने, तो ये 2-3 दिन में थोड़ा टाइम निकाल के बनाया था, तो मैं चाह रहा था कि थोड़ा शेयर हो जाए। एकेडमिक गैदरिंग यहाँ पर है, नहीं तो आपको तो पता ही है मुझे क्या आता है। बस आपने अवसर दिया बोलने का, मेरे लिए बड़ी बात है।
There's no doubt about it. And we will share your PPT with our students. We are sharing all the PPTs that we are getting
जी मैम, जी
to our alumni lectures.
जी।
It's the treasure of the department. You continue, Saman.
Okay. Okay. So let us turn towards the natural law theory, which has underpinnings in the Sophocles and Aristotle, but it was first elaborated by Stoics of the Hellenistic period and later of the Roman period. Natural law, in fact, read those elementary principles of justice which were right religion in accordance with nature, and these are the unalterable and eternal things. So in the medieval period, in fact, we have seen that the natural law theory was not helpful even to the development of the law as well as to the protection of the rights of the persons. But later on, when the period of Renaissance came, the number of things changed. सुप्रिया मैडम अपने हिसाब से स्लाइड चेंज करते रहा करिए, है ना, क्योंकि स्लाइड को थोड़ा सा लेके चलना मुझे आई एम फाइंडिंग सम डिफिकल्टी.
जी सर,
again and again to turn the slide, in fact, is
okay sir,
not
okay
suitable
sir.
for me.
I'm listening.
You keep just changing slide. You keep changing slide as per your convenience. Okay. Wherever
okay,
finding me, if you find that some slides are relevant, just you show there if it is possible. Otherwise, no problem.
Okay, sir.
So,
Sure, sure.
Grotius was one of the natural law philosopher, and he is, in fact, known as the father of the international law. He had attempted to define the natural law. He said that the natural law is in fact a dictate of right reason, which points out that an act according to it as it is or is not in conformity with rational nature has in it a quality of moral baseness or moral necessity. So thereafter, we have theory of John Locke. John Locke was one of the chief exponent of this theory. He developed his philosophy within the framework of the 17th century, 17th century humanism and political activity. Locke had in fact imagined the existence of human being in the state of nature. In that state, men and women were in the state of freedom. They were able to determine their actions and also in a state of equality in the sense that no one was subjected to the will or authority of the another. ये अगली स्लाइड पर होगा मैडम, अब तो वही रुकी पड़ी है, आप देखते रहें, आपको मिल जाएगा उसमें. So Locke in fact denied subjection of one person to the other person. He said that every individual has its own autonomy, and there's and they retain, though they have entered into the social content theory for the formulation of the state shape, even though they have retained their certain natural rights, for example, a right to life, liberty, and property, in terms of the right to life, liberty, and security in terms of right to property. And every government is obliged to respect, to protect these natural rights of their subjects, and if government is failing to do so, then the people have right to overthrow that government. Though we know well that natural law theory was in fact later on during the 19th century was abused, misused, overused by the state, saying that the state is a natural authority. So the person's right to hold liberty, property, these are subject matter of the state, and the state would decide. In spite of these controversies, or in spite of these defects, the natural law theory has succeeded to assign autonomy to the individual, and this autonomy was in fact directed towards a recognition of a right to life, right to liberty, right to property of the individual. So let us trace another philosophical foundation of the human rights. In fact, here we are inquiring that nowadays what human rights we have, what philosophical foundations these human rights have. So if you are able to see my next slide, you will find that I have tried to explain over there the positivism. In fact, theoretical positivism, well known by the great contribution of Austin. The positivism has established authority of state. You will not disagree with me if I'm saying that whatever human rights you may claim in the international arena, you cannot enjoy either of those human rights unless your state has not devised some mechanism for its enforcement, or state has not availed some infrastructural support to you for their enjoyment. Take example, in Article 6 of the ICCPR, there is a provision that no person shall be deprived from, state shall not deprive any person from his right to life, sounding same as in Article 21 we have in our Indian Constitution. But in Article 6 of ICCPR, there is some exception to this basic right to life. And under that exception, the signatory states, state parties have been allowed to maintain provision of capital punishment in their statutes. But what has happened? After the second optional protocol to ICCPR, the death penalty has been totally abolished. Now, the right to life, which has been made one of the basic human rights of every individual, to be implemented across the globe, throughout every country. Now that has been made intact. No signatory state party can refuse to abolish the death punishment from their legal system. In spite of that, though that has been executed and in fact corrected, some European countries have corrected their own, have corrected their statutes, and they have abolished that sentence. But if you look in Indian legal system, still we are having the death punishment, death sentence. Though that sentence has been abolished under ICCPR, but in India still there is death sentence. So if any person who has been awarded with the capital punishment can claim that this punishment is violative of his human rights, so declare of the ICCPR. This positivist theory says that whatever human rights have been declared internationally, globally, regionally, cannot be availed to the persons unless the state within which jurisdiction he or she is has not legal development in its own legal system. Some mechanism has not been restored. So, in fact, it is well known to everyone that the theory of positivism has started with the rejection of a priori source of rights, with very criticizing comment of the Bentham, who declared and considered natural rights as the bowling on paper of quoted is his colorful attack. Right is a child of law, he said. From real law comes real rights. If there is some imaginary law, then there will come some imaginary rights. And the real rights, they are the imaginary rights. They are rhetoric, nonsense upon stilts. Very high level of criticism when Bentham said about the natural right that it is a nonsense upon stilts. So, dear friends, We are well aware about the contribution of positivism in the development of legal theory. In the same manner, this positivism has given some articulation to the implementation of the human rights in the national domain. Here, the holder of human rights can only be a human being, and the state is the duty obligator. Every human being who are holding rights, these rights are against the states. This is the conception which is emerging from this one. And unless and until there is no relation between the person, that is the right holder, and the state, that is the duty obligator, there won't be existence of human rights. So he said that this theory in fact informs us that there are three things, three components of human rights. First is there should be one right holder, there should be one duty obligator, and there should be a legal relationship between this right holder and duty obligator. I think you are not agreeing with me, so I am forced here to give some example to you. Every person has a right to freedom of speech and expression. This is the human right declared under UDHR and ICCPR as well. But in India, this right is available only to the citizen, not to the persons, under Article 19, Clause 1, Subclause A. Meaning what? Right holder of this right is the obligator is the state, and this right may be available to the human being only when that human being has some legal relationship with the state. That is being a citizen of that country. In the similar vein, take example of it's not happening. In the similar fashion, if we take example of the political right, in political right, every person has, if he or she has reached to the age that has been prescribed by the law, voter, he or she may cast vote. He or she may contest election. But while the election of a country is going on, any alien can claim to cast the vote or to contest the election. It is not possible because that alien is not having any legal relationship with the state where the elections are going on. So dear friends, this positivistic theory informs us, in fact, about this relationship between the individual, that is the human, and between establishing authority of the state. Move on and try to find out some basis of human rights philosophy under the Marxism. अगले स्लाइड पर जाएं थोड़ा मैडम सर. ये थोड़ा मैंने बनाया, ढूंढ ढांड के मैटर निकाला है इसको, तो इसको आप देखेंगे तो यहीं से काफी चीजें क्लियर हो जाएंगी. अब मार्क्स इज वेल नोन टू एवरीबॉडी. If I am speaking more and more about Marx, that will be less and less. So better for me. Marx has never seen man as individual or man as auto has been declared in the natural law theory. But Marx has always seen man as a species being. And a species of what? A species of the society. So I'm not going to read the slide, but I'm just speaking in a nutshell. When Marx says that the law of nature approach to the human rights is idealistic and it is ahistorical. There's nothing natural, nothing inalienable about the human rights. At the same time, he says that whatever right is there, that is only with the society. And if the social rights of the species of the society, the rights of the persons would also be fulfilled. And the society contains the collective rights. And within this collective rights, within this collective rights, the are existing, or you can say that they are included. So the state has to offer services to the society to fulfill the ends of the society, instead of fulfilling the interest of the individuals. Marx says here that the needs of the individuals, in fact, the state is fueling up to the capitalism. Only few may enjoy their own rights. And when the society is capitalistic, then talking about the human rights within this framework of the capitalistic society is nothing more than the bourgeois illusion. So better we to take control of all natural resources, and state has to fulfill the rights of the individuals in accordance to fulfill the rights of the individuals, maintaining balance of the societal rights. So what has happened later on with the modern Marxists? The theory sounds very good. The Marxist theory sounds very interesting, and sometimes it is astonishing us that towards the Plato's utopia, Ram Raj, where everything has to be controlled. Persons are required not to be worried of their safety, security, education. They are supposed only to do their duties. In the state. But what has later on happened with the modern Marxists, in fact. They attached everything with the state. Now, state has started setting goals for the society. And now the persons turned slave to these goals so set by the state to be achieved by them. Eventually, this Marxist theory, which started with very progressive ideas of fulfilling economic rights of the persons, has eventually started suppressing rights of the persons. Now persons are not as free as they were supposed to be. So the greatest contribution of the Marxist theory is, what I can say over here is, that it has in fact started thinking about the economic rights, what we see in the ICESCR, which has been internationally recognized. Right to work, right to good condition of work, right to wages, right to education, right to housing, right to everything which is related with the economic affairs. Now move ahead, madam. You can stay here. There is one difference between the Marxist theory and the Western theory. In Western theory, what is in fact there, the human beings are autonomous. But in Marxist theory, human beings are not autonomous. Rather, their needs are to be achieved, meeting the will of the whole community. Yes, madam, go ahead. Now, second last philosophical foundation which I want to take up here is sociological approach. The sociological foundation of the human rights. Herein, we will find that this approach has connected human rights with the society. It has connected human rights to the state, and it has brought state as well as the society and the individual very close. This is the empirical approach of the human rights, in fact, which has informed to the lawmakers or to the policy makers to take social process in action. Please turn to the next slide. There are a number of the contributors in this sociological school, but I don't have much time to speak all of them. So I am here just concerned with the contribution of Roscoe Pound. And Roscoe Pound is not unfamiliar to any of the persons present over here. He catalogued interest as the individual interest, public interest, social interest. And he gave his principle of social engineering to maintain a balance. In his guiding principle of social engineering, he attempted to maintain a balance from the end of the estate among these catalogs of the interest, that is the individual, public and social. But how it has to be maintained and which rights have to be given more preferences was his failure. He couldn't devise any mechanism in a perfect way through which the state can give preference to one right over the other right. Though in his social engineering, very famous dictum given by him was, the purpose of law is to augment or to fulfill maximum of wants with the minimum of friction. Then which want, individual, social, or the public, should be given preference when there is a conflict. Nevertheless, contribution of this theory cannot be ignored. In this slide, I have given some catalogs of rights presented by Pound. This is you can see. Otherwise, we can move on to the next slide. Then we are forced to move towards the last basis of philosophical foundation of human rights. That is the theories based on justice. John Rawls is here. But one thing I want to remind you that in the sociological approach, the greatest contribution was to make us result oriented, to make us sensitive towards the conflicting interest of the individual, social, as well as the public interest. So here, last theory which I have taken up here, theories based on justice. This is the John Rawls, and John Rawls is a treatise is well known to everybody, a theory of justice. And herein he is saying that justice is the first virtue of social institutions. Human rights are an end of justice. Consequently, the role of justice is crucial to understand human rights. According to Rawls, principle of justice provide a way of assigning rights and duties in the basic institutions of society. So Rawls' thesis, go on to the next slide. Rawls' thesis is that each person possesses an inviolability founded on justice, which cannot be impaired or which cannot be ignored, even in the welfare of the society. Means the rights of the persons which are founded upon the theories of justice cannot be compromised in any other situation. So justice denies that the loss of freedom for some is made right by a greater good shared by the others. Again, this is not allowed by the justice. In his thesis, he is saying that in a just society, the liberties of equal citizenship are settled. The rights secured by justice are not subject to political bargaining or to the calculus of social interest. But what is there? In my next slide, that is, next slide please. Then here, Rawls has imagined a situation wherein he wanted to bring men and women together, and to set them in the original position, from where everything is started. To that position, Rawls is assigning one term, original position, and he is saying that in the original position, every man and women had equality with respect to power and freedom. They were equally encumbered by a veil of ignorance about their own particular qualities. Thereafter, Rawls is opting two principles of justice. In his first principle, in fact, this is the principle of reconciliation of interests. In this principle, John Rawls says that each person is to have an equal right to the most extensive total system of equal basic liberties compatible with a similar system of liberty for others. Liberty can be limited by liberty only, not by any other class or category of rights or interests. Liberty of one person can be curtailed only when it is causing hazard to the liberty of others or hazard to the liberty of the society. To his first principle, Rawls is asserting that this is my principle of reconciliation of interests. If there is a conflict, then that has to be reconciled. Then in his second principle, Rawls says that social and economic inequalities are to be arranged so they are both to the greatest benefit of the least advantaged and attached to the positions of offices open to all. To his second principle, Rawls assigns it difference theory or distributive justice theory of distributive justice theory, and it is well known to everybody. In distributive justice, what is there? The least advantaged persons should be given preferences over the advantaged persons. Take example of reservation policy. We have been taught that this is not constitutional only from the point of reasonable classification arranged under Article 14, arranged or allowed under Article 14, rather to say, but it is, we have been taught by our professors that yes, this is the demand of distributive justice, this is demand of theory of justice, that the persons who are at present least developed should be given priority, should be promoted through some policy, so-called reservation of whatever nature, to come into mainstream of the development. So from here we have gathered, from the point of theory of justice, we have gathered some information that how जरा अगला वाला स्लाइड देखिए, कुछ है या खत्म है मैडम शिवप्रिया मैडम? हाँ, खत्म है. So from these theories or the foundations, we have gathered many informations, in fact, that what human rights right now we have, they have some sort of philosophical foundations as we are having in the theories of law. and these philosophical foundations of human rights are still under preparation, because human rights, the dimension or origin or the concept of human rights is evolving. In the beginning slides, I have shown to all of you that what human rights have been declared universally, or have been designed for all human beings throughout the world, being at any place. Now, those human rights are also taking new shapes, new designs. So who knows, in future we may get new varieties of human rights under auspices of United Nations General Assembly. So these are the things. So I would like to wind up my interaction, ladies and gentlemen, with a very famous anecdote of Professor Gertrude. When she was on the deathbed, Professor Gertrude was on deathbed. Then she asked to her fellow philosopher friends that what is the answer, what is the answer, what is the answer. One of her philosopher friend leaned over and he spoke something into her ear. Then Professor Gertrude closed her eyes and took sigh and said that then what is the question, what is the question, what is the question. So dear friends, what is the answer? If you are moving to find out the philosophical foundations of human rights, then we can go to very short distance. But what is the question? If we are beginning with this concept to find out the philosophical foundations of the human rights, of course, we can go very long. So thank you very much for listening me, for giving this opportunity. मुझे तो वास्तव में बहुत जो है क्या कहना चाहिए, मुझे जो है झेप लग रही है कि मैं जो है माता समान प्रीति मिश्रा और सक्सेना के सामने मैं बोल रहा हूँ, और बहुत सारी त्रुटियां हुई होंगी, मैं क्षमा चाहता हूँ मैं। और अभी तो चूंकि ह्यूमन राइट्स का जो फिलोसफिकल फाउंडेशन है, जैसा कि मैं जान पाया हूँ कि अभी तक ये अंडर मेकिंग प्रोसेस है, अभी उतना मेच्योर्ड नहीं है जितना कि अपना जूरिस्प्रूडेंस थ्योरी ऑफ लॉ अपना हो रखा है। तो जितना मैं समझ पाया था मैंने कोशिश किया, हालांकि इसमें भी बहुत सारी चीजें हैं जिस पर कि मुझे आप लोगों से भी सीखना है और कुछ और पढ़ करके निकालना है। प्रोफेसर BL शर्मा सर हमारे वाइस चांसलर थे यहाँ पर, तो मुझे अपॉर्चुनिटी मिली थी उनके क्लास लेने का, जो पढ़ाते थे हमारे फर्स्ट बैच को। तो काफी कुछ मैंने उनसे भी सीखा और देखा, कुछ लिटरेचर वो देखे गए थे, तो मैंने, हाँ मैं माफ करिएगा, शुरुआत में मुझे उनका नाम लेना चाहिए था, मेरी ईमानदारी होती है, क्योंकि whatever I have spoken over here won't have been possible if the contribution of Professor BL Sharma had not been there. बाकी दोनों मैम यहाँ पर हैं, दोनों को मेरा प्रणाम, सबको बहुत बहुत धन्यवाद।
Thank you, Aman. Thanks a lot for such an extensive coverage of the topic. The creation of human rights, and it could have been more elaborate, but due to paucity of time, I know that it has been very exhaustive. Distance. We have covered a lot of points, and now I would like to request our senior professor, Professor Vishwavidyalaya, to say something about our beloved student, Saman Narayan.
Thank you, Professor Mishra. And thank you so much, Saman. You have just given the entire philosophical aspect of the origin development of human rights. And as you have rightly pointed out that we have not reached to that limit, we have not reached to that goal for which these human rights declarations have been made. And if there would be some more time, I think that you must have also spoken about on the realistic approach of the human rights, the
जी जी
philosophical
जी
approach of the
जी
realist or realism,
जी
because that's the sister concern of the sociological school of law. And in that realism, you see that right to internet and right to technology benefits and all
यस
these are the part of the UDHR as well as ICCPR. So now that is the expanded area where we are finding that where we can see the human rights as such. So because of the paucity of time, I think, and due to the bad connection also, because you are in Chhattisgarh, and I think that the this Wi-Fi connection is not uh, going with your work. So, of course, but you have made a very wonderful presentation here on the philosophical aspects, and I think that the students who have attended this lecture must be benefited with this lecture also. So thank you once again, Professor Mishra, for devising such a beautiful lecture series of the alumni. Thank you very much for giving me the opportunity also. Thank you so much.
Thank you,
थैंक यू
ma'am.
मैम
Thank you so much for always being a pillar of strength and encouragement for the department. We do seek your blessing in future also. Now I would like to request Jitin Kumar Saroj, our research scholar, to propose a formal vote of thanks.
थैंक यू मैम।
मैम परमिशन हो आपकी तो मैं दो शब्द थोड़ा सा
हाँ हाँ बिल्कुल।
जी मैम अभी 2 मई को मैंने एक नेशनल रिसर्च सेमिनार ऑर्गेनाइज करवाया हुआ था। थीम हमारा था कंटेम्पररी इन्वायरमेंटल चैलेंजेस इन इंडिया। तो इस पर मैम गुरु गोविंद सिंह यूनिवर्सिटी से प्रोफेसर अमरपाल सिंह सर आए थे। आप लोग जानते हैं मैम उनको इन्वायरमेंटल लॉ के बड़े अच्छे प्रोफेसर हैं, प्रोफेसर अमरपाल सिंह सर। और BHU से मैम आई थी प्रोफेसर मधुलिका अग्रवाल मैडम, बॉटनी से है वो। तो मैम मैं आगे जो है इन्वायरमेंटल लॉ पर ही कुछ और भी सेमिनार करना चाहता हूँ, और मैं चाहता हूँ कि आप दोनों मैम उसमें मेरी जो है एक रहे किरण स्पीकर और एक रहे हमारा उसकी चीफ गेस्ट। तो मैम मुझे भी यहाँ सेमिनार्स कई करवाने होते हैं, हमारे VC सर का बड़ा प्रेशर रहता है कि हर डिपार्टमेंट हर 2 महीने 3 महीने पे कार्यक्रम करवाएगा। तो मैम मैं तो वैसे फोन करके आपसे बातें कर लेता, लेकिन मैंने कहा कि पब्लिकली मैं आपसे परमिशन ले लूं, आपका आशीर्वाद ले लूं।
मतलब लॉ के स्टूडेंट हो के एविडेंस इकट्ठे कर रहे हो।
We are really honored. We are really honored and would like to be the part of the program that are going to be organized by you. So all the very best for your all the prospective future endeavors, whatever you are going to do.
Yeah.
May God bless you with all His grace and everything. Now,
He's a good organizer, and earlier
Yeah.
also he organized one
Yeah, he has done a lot of
international. I was there.